This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the third season of Murgatroyd's Innovation Talks podcasts. We're delighted you've joined us. If you have any questions, please get in touch by email at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. Don't forget to subscribe to make sure you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Eleanor. I'm a trademark director here at Murgatroyd in the Glasgow office. Today I'm joined by Catherine Bonner, a patent director from our Southampton office.
Hello, nice to see you, Eleanor.
Today we're going to speak about innovation support.
To accompany the podcast, you may wish to look at the description notes in the accompanying box, and this outlines the life cycle that you may see in a product or in a brand, and we're going to be talking around how Murgatroyd are there for you along the journey, every step of the way, and at each point on that journey, Eleanor and I will now discuss different aspects of intellectual property and the support provided.
So, commencing with create, when you're first creating either a new product or a new service that you're going to be launching into the marketplace, you would really want to be looking at undertaking a trademark clearance search to check that name is available for use. You may also wish to contact us to have advice as to whether any other aspects of the product or service could be registrable.
Absolutely, for trademarks. There's lots that I'm sure you do on a day in, day out basis, Eleanor, for brands, logos and everything around the trademarks. From a patent or protection of technology side of things, at that first blank page, if you like, when you're setting out your ideas, it's always good to get in contact. We like to help throughout the process. We can really provide great input across a whole IP strategy for a new product. And in those first early stages, we can conduct intellectual property searches, patent application searches, and help with patent landscaping and mapping the area you may be first going into.
And Catherine, isn't it important at that very first stage to keep your idea, if it potentially is able to have a patent, quite confidential?
Absolutely. In order to be granted valid patent protection at the end of what is often a very long patent prosecution journey, it's crucial that the idea must be kept confidential. There must have been no non-confidential disclosure of the information prior to putting a patent application on file. No disclosure outside terms of confidence. Non-disclosure agreements, which we advise on very regularly, are crucial at that stage. Yes, absolutely correct.
So that's why really for a client or a potential company, it's really important to seek early advice at that very early creation stage.
Yes, completely. Early advice addresses or helps to address any problems that might arise later. Moving on from the creation stage, when I see companies who have a more crystallised idea of a product or a method, an application they wish to go ahead with, it's at that stage that we often use our invention harvesting forms or invention record forms, as I call them. We can really record accurately there with the inventor how a product or a method operates, the important steps, and from that invention record form we can then go ahead and prepare and file a patent application. Or for something that we're talking more about the structure or the shape, then we can go ahead and seek registered design protection. I should imagine you have a similar way of capturing information about trademark?
Well, it tends to be after the initial creation stage. Quite often we will then see perhaps a sample of how the product or packaging is going to be looking, and we will actually then discuss it with the client what elements of that could be protectable by way of trademarks. Is the stylisation of the logo or the word such that you might want to have a separate trademark application for that to make sure it can't be copied? Or is there something in the packaging itself, the shape, that you perhaps want to also additionally look at? And we would then, once we have that initial sort of visual of the product, be able to discuss with the client what protection potentially is available to them so that they have the options to decide whether to pursue it or not.
Yeah, absolutely. One of my most exciting things I think I worked on in my very early days of being a patent attorney was a box to hold a champagne bottle that would arrive through the post and sort of explode open. You're absolutely right. Seeing that first prototype is exciting and really important to capture everything at an early stage. The length of time it takes to secure a granted patent can be 3 to 4 years. It's a long process, but that patent prosecution or registered design prosecution is something that we're here to help with along the way, to assist and to present the most advantageous case to the relevant intellectual property offices in order to try and secure those rights. We do that day to day for patent applications, design applications, and the same for other rights.
Yes, trademark applications are, they can be filed fairly quickly once you've actually decided what it is you actually wish to protect. And your rights will arise from the date of filing. And that's the same actually for design registration as well. Do the rights for patents, do they arise at the date of filing, or is it at the date of final prosecution?
You sort of plant the flag with your initial patent application. You say that these are the rights that you wish to own, that you wish to stake your claim to. You cannot enforce those rights until much later when you have a granted patent. Everyone is put on notice once the application is published, but again, that's not until 18 months after first filing. But yes, it's really important to stake your claim, plant your flag early on.
Yes, it's the same for trademarks actually. You cannot enforce your trademark registration until the registration is secured, but the process is very much faster, being literally a few months down the line.
I'm always quite envious of your speed of trademark registrations occasionally, yes. And of course, once you've got those rights, it's really important to manage those rights, to pay the relevant fees at the right time. And there's no point going through years and years of prosecution if you make one fee payment and then have lost your rights. So yes, really, really important to have good management in place. And I would also argue that it's good to prune and to look carefully at the rights you have so that you're not keeping rights that you no longer use and that are no longer of any use to you in the marketplace. So you should be active management, I think, is quite important.
Yes, definitely. I mean, for trademark renewals, quite often when we are at that stage, we would be looking to see what actually is still being used. Well, the registration will last for 10 years, so you have quite a long period of time before you then have to consider whether or not you wish to maintain it. Trademarks don't actually have any fees in the interim from when we secure the registration to renewal, but that's not the case for patents, is it?
No, in some jurisdictions you have to pay annual maintenance fees even while your patent application is pending, and then obviously there are renewal fees once the patent is granted. Throughout that lengthy prosecution period, though, I think it's important to look at the landscape in which your patent is inhabiting. Who else is active in the field? What are they looking to protect? Are there additional applications you need to make to supplement the first one that you first filed? Really building a series of obstacles, hopefully, for your competitors, and incrementally protecting every single advance that you go through, so that a patent will only ever last for a maximum of 20 years from the application date. That's unlike trademarks, but 20 years can, relatively speaking, go quite quickly. So it's crucial to be thinking about protecting your next innovation. So the very first right may have expired, but you still have protection for your improved version. That's different for trademarks, I think.
Yes, and certainly when it comes to regenerating trademarks, it tends to be actually the new product or a new trademark filing, which is in fact actually required, because often the life cycle of a product or its branding may only be 5 to 7 years, and even well-known brands perhaps tweak the stylizations, what is deemed to be in trend at that particular moment. Particular colours come and go, and therefore things are tweaked, and it may be the case that actually you have to look at the product before even the trademark renewal is due and say, does this protection match with what the product actually is on the marketplace? And when we do always recommend word only for the actual product name, so that you don't have to be so concerned about stylization changes.
I think it's also really important for individuals and companies to understand what they've got. I think an IP portfolio, an actively managed, up-to-date IP portfolio, is really important, so that everyone in the marketing department knows how to use the trademark. It's no good having some beautiful right if actually you're using it on all of your packaging in some other way. It's no good having a wonderful patent if you've tweaked it and your product that's on the marketplace doesn't function and operate in that way. I do quite a lot of this updating and management with my clients, one in particular who I visit every other month, and we run through the whole portfolio and check that it's still fit for purpose. I think that's really, really crucial.
Yes, it definitely is very key. And the same again, that will arise for trademarks.
The life cycle really is an ongoing piece of work.
Yes, I think more so for patents than perhaps for trademarks. You seem to have to do a lot more innovation support on the journey than perhaps we do for trademarks.
Always happy to help, and I always enjoy it when I think, oh, maybe that could be a trademark, but I refer someone on to for your expert advice on that. Yes, ongoing support and ongoing journey.
Thank you, Catherine, for sharing your experience with me today. It's been lovely talking to you about innovation support.
Thank you, Eleanor. It's been a great conversation.
Thanks for your time today. We hope you found today's podcast valuable. And don't forget to subscribe to make sure you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.